Okay, we are ready to roll. At this time, we don't necessarily have a 2021 chairperson. I know we have a roll call as the first item on the agenda. I think Deputy Clerk Cathcart's going to run with doing the clerk piece of this. Cathcart, do you want to do the roll call so that we have on the record who is present?
Yes. Barbara Scheinberg. I see you. I don't hear you.
Looks like
Emil
she's
Mackey.
muted.
Yeah.
Emil Mackey's here.
Okay. Emily Haynes.
I'm here.
Barbara Meekum.
Here.
James Coleman is absent. Kenny Solomon Gross.
Present.
Raymond, do you go by Thor or Raymond,
Thor.
Mr. Williams?
I
Okay,
usually go by Thor. So yes, I'm here.
thank you. David Epstein, Stein.
I've been called worse. I'm here.
It's always the opposite of what I want to think of. So, and Gary Sonnenberg.
Gary's here.
Thank you.
Hopefully you can hear me.
Yes, we can hear you just great. Thank you, Mr. Sonnenberg. We do have a quorum.
And I'm going to interrupt Ms. Scheinberg if you want to check your audio. I know we didn't get to hear you previously.
Oh, that's because I stepped down to get a piece of toast, but I'm here now.
Okay, good deal. Okay, so first order on the agenda is the election of officers, and generally we elect a chair. And then with the Board of Equalization, one of the interesting things that we end up doing is we have panels of 3 individuals plus an alternate. And then each panel at the time that they meet selects their presiding officer during that panel. So do we have any nominations at this time for someone to serve as the overall chair of the Board of Equalization? Oh, I'm sorry. I should have introduced myself. I'm Beth McEwen. I'm the municipal clerk. Deputy Clerk Diane Cathcart just went through your roll call, and we are your staff assistants to the board. So any nominations from the floor for a chair member at this time?
Madam Clerks, it is my honor and privilege to nominate David Epstein, or Stein, he's been called worse, as our Board of Equalization chair, and I ask for unanimous consent.
Second.
Thank you, Mr. Solomon Gross and Mr. Mackey. Mr. Epstein, is that amenable to you? And are you willing to be nominated?
Amenable and willing. Thank you.
Okay, are
Kenny,
there any
I
other,
owe you.
are there any other nominations from the floor before we close the nominations? Hearing and seeing none, unanimous consent has been requested. Are there any objections to the motion? Hearing and seeing none, Mr. Epstein, you are duly elected chair, and I will hand over the virtual gavel to you, sir, and let you preside for the rest of the meeting. Thank you.
You're welcome. And guess what? I don't have the agenda up. I'm caught cold.
Would you like us to share it on the screen? Would that be helpful?
Go ahead, please. Yes, I'd appreciate it.
Let me pull it up here. I think I have it. Oh, there you go. Perfect.
Okay, thank you. We've gone through the call to order, the roll call, the election. The next item on the agenda is a board training / refresher. presented by Assistant State Assessor Joseph Cassie. And the CBJ Law Department training with law staff. On behalf of the board, I thank you for being here and helping us this evening. Mr. Casey, if I've got your last name correct, the floor is yours.
All right. Hi. Yeah, you got it right. About 1 out of 2 chance. People usually get that wrong, just like Epstein.
And Mr. Casey, before you begin, I did see our assessor, Mary Hammond, with her hand up. So before we really get in, Mr. Epstein, I don't know if you can see the other panelists or the folks when we're sharing the screen. So if you do want us to stop sharing the screen at some point, we can do that as well.
I'll let you know. Go ahead, Mr. Casey.
Oh, hi. Did Mary, did you have something to say, or I'm
Thank
happy to
you. I just wanted to add that the assessor's office will also be presenting after the state assessor and before the law staff.
Okay. All right. So if we're ready to go, looks like, do you have my presentation here? Great. I can share my screen. It's a slideshow, so maybe that might work better if you only have a PDF of my show. So let me see. And let's see. Okay, so it looks like you can see this. I guess it's going to be in slide. Is it? Are you seeing the regular show or my personal
We're
deck?
seeing your preview personal deck.
Okay. This still might be a little cleaner. I don't know. Do you think so, or do you want to use your PDF?
I think this looks good, Mr. Casey.
Okay.
Yeah, you know where you're gonna go with it.
Cool. Okay. All right. So here's this training that we kind of do for all the boards of equalization every year. This is my first year being completely solo on this training. I'm the acting state assessor, not the assistant right now, but that was my job until Marty McGee left. If you've been on the board for a while, you probably know him. I have a little bit more of a legal background than he does, and that's how I kind of view this issue. So that's kind of how I tend. But if you have any questions at all, I'm happy to be interrupted during the show, during the presentation. So let's get. What was that?
Oh, there was a long. Yeah, can hear you. Sorry. Okay,
great. Yeah. I can't see hands, so whoever is the chair or the clerk or whomever, if someone notices someone has a question, feel free to just say, hey, we got a question. All right. So we're kind of going over why this is I wonder if we're missing a slide here. Anyways, kind of as an overview of what this is about, there's some important points we're going to be touching on over and over again in this presentation. And that's because those are the things that are both the most important and kind of the easiest to get wrong. I'd say the two points of this list of 5 that I really would want to touch on is the things that maybe I know before I went to law school, these would have been maybe meaningless to me or counterintuitive to me. And so the first one that I see here is decide based on the evidence presented, only based on the evidence presented at the hearing. That is very important. And then follow due process, which kind of is a catch-all term. And so we'll try and fill that in with some content before we end tonight. But those are going to be the 2 that I really think of this list are the most important. And we'll talk about the others as well, but that's just kind of an overview of what I really want you to take away from this. And you'll have this afterwards, so you can look over it, and you should have my email too. If you have questions, I'm always happy to answer things afterwards if for some reason I wasn't clear tonight. Okay. So property tax system consists of two different parts. There's the assessment system part, and there's the tax billing and the collection part. So assessment is done by the assessor's office. That's Mary. Tax billing and collection is usually done by finance. Sometimes it's done by the assessor, but I believe in a city as large as Juno, you'll probably have a separate part. And the part we're dealing with is the assessment. That's what's being appealed. And we'll talk about why that split is important and what you are supposed to do and what you aren't supposed to do. The reason this is important is, I just bought a house in the last couple of years. It's my first house I've ever bought, actually. And suddenly I have a big tax bill due. It used to be probably part of my rent in a way in the past. But now the big bill that I pay to the municipality is property tax. Juno does have a sales tax, but up here in Anchorage, it's kind of all I paid to the municipality. So it's kind of my biggest interaction with the city. So getting this part right, or worse, not getting it right, kind of could leave a bad taste in my mouth. So it's important that that this process, when someone is appealing, they feel like they've been heard and they've been treated fairly. And someone's going to lose, and at least probably about half the time, probably more than that, to be honest. It's going to be the appellant, and they're not going to feel great about it. And even if you treated them fairly, might not make any difference, but it is important to treat them fairly as opposed to not treating them fairly. It's easy to think it won't make any difference because they're probably going to be mad no matter what if they lose. But if they were treated unfairly, they're probably going to be a lot more angry and feel a lot more cheated. So this is kind of guides to help treat these people fairly, and also to make sure that you don't make mistakes in general. Okay, so here's the definition of mass appraisal. And the reason we point this out in a larger jurisdiction, I know a good number of the members of the Juno Assembly, and I don't see them here, so I infer from that your Board of Equalization is appointed. And usually it's appointed, it is not the Assembly, it's a separate Board of Equalization. And often people who are appointed have some sort of background in real estate. Often that means they themselves are appraisers. And so it's important to establish that this is mass appraisal. It's not fee appraisal, which is what a lot of people might be familiar with. It's a different process. There's this sort of broad statistical testing, and I've looked over what the assessor is presenting, and they'll get into that plenty about what they do, but it's a little different than going to individual properties and assessing one at a time. So it's important to have that concept in mind when you're deciding whether a fair job was done or not. So here's kind of what we're going to be talking about. I won't read this off, but kind of a preview of the questions we're going to be hopefully answering here. So the Board of Equalization is the adjudicator, and here they play all three of these roles. So a judge in a courtroom, by analogy, is the person who interprets the law. So they're an expert on what the law is and how to interpret it. Well, you're the expert on what the law is and how to interpret it. Juries, we often call the fact finders. They're normal citizens. They don't have any special expertise. But if we are asking basic factual questions rather than law questions, we want people from the community. When I'm talking about a jury here, we want people from the community to be able to answer those questions. Is there a garage attached to that house, or is that a carport? Is the land slanted or is it flat? That's something that an ordinary layperson could decide on. Well, did the person deal heroin at 9 o'clock on that night? That's another fact that a jury could find. The judge decides what's the penalty for that. you know, what evidence comes in, but juries decide that. Well, Board of Equalization also is a fact finder here. So they play the role of the jury. And then the cross-examiner, which is a really interesting role. Usually that's done by opposing sides, but in Board of Equalization hearings, the opposing sides don't have the opportunity to directly question each other. They're interacting with the Board of Equalization directly only. And so we'll get into this a little bit more, but later, but it's an important role. If you think that you know, cross-examination is usually a negative thing, right? Because it's the other side. But if you think that one side is presenting something maybe in not the most helpful way, you can redirect their line of argument. You can say, well, what about this? You know, if you need to hear something from them that might make a difference and they're just not articulating it, maybe they're probably a lay person, just a property owner. They don't have the right vocabulary, but maybe they're saying something that you think, well, I need them to say this, you know. You have the opportunity to ask them a question and get them to talk about something if you're wondering about something. Also, though, you can do a more adversarial cross-examination. You can, if you doubt something they say or it doesn't make sense to you, you can, you know, try and poke them apart a little bit too, if what they're claiming doesn't make sense. So those are all three roles are played by the Board of Equalization. Okay, so here again, we said this is a quasi-judicial hearing. It's not, you aren't judges, but in many ways it is like a court of law. So think like you're a judge. You want to be fair to both sides is the fundamental idea, and we'll talk about what that means. There's due process it has both specific and general requirements. So again, another thing that this slide touches on is the fact that you need to be thinking about the possibility that the decision that you make on this day of the hearing might be reviewed by the Superior Court. That's the next level of appeal. And so if it were to be reviewed, is the Superior Court going to be able to uphold your findings? So the worst possible thing is not that you get reversed by the Superior Court, not that you made a bad decision, is that you made the right decision, but you didn't make it with enough specifics. You didn't even allow the Superior Court to review, because that's the much more common thing. You folks are probably very good at this, and you don't make bad decisions. But what is much more common is that a Board of Equalization will make a good decision that's just totally justified. It's, you know, the right decision on all the evidence, but they forget to say, well, why did they make the decision, or they don't make it with enough supporting facts. And some people who are appellants are just bored or spiteful. And even if it's over, you know, $1,000 worth of property tax, they'll take it up to the Superior Court. And the Superior Court will say, oh yeah, you didn't do it right. And it has to get remanded back to you, and it's expensive for everyone involved. And so that's what this training is about avoiding. And so if you think about, and we'll talk a little more about this, you think about what's the next step, what's sort of the next branch of the game tree, sort of, where are we going next? You can kind of cut that off. You know, you don't give them, you know, it's one of those things, if you think about the possible appeal, you probably won't have to deal with the possible appeal because you'll avoid it. Okay. So here is something we'll get into a little more as well. We're just going to be repeating some points on some of these slides, but they're important. But the point of this slide is essentially that it's the assessor's job to set values. One of the things that I'm relatively new to this whole field, but one of the things I've learned is that it seems like if you gave 5 different appraisers a property to appraise, they'd come back with 5 different values. That doesn't mean that any of them are wrong. It doesn't mean one of them is right. It's that there's room for error in opinion. And so if you, for some reason, would have appraised a property differently from what the assessor did, that's not necessarily your job. The question is, did the assessor do it wrong in such a way that is worth reversing? Then it might be time for you to put your appraiser hat on and figure out what is the right value, but only then. If the assessor did a sufficient job, doesn't have to be the job that you would have precisely done. If the assessor did a sufficient job, then it's not time for you to set your own value. Okay. So here we've got statutory citations here sprinkled throughout here. These are useful if you need any sort of anchor to go back to. At the end of this, there's also there's an appendix. It's got all the statutes, the important ones listed. So important here, the appellant bears the burden of proof at the hearing. So my analogy to the burden of proof is if both parties came in and sat down and said absolutely nothing, the assessor would win, because you have to do something in order to shift that burden of proof. You have to overcome the burden of proof and show that something is wrong. And what do we have to show that was wrong? One of these four things: unequal, excessive, improper, or undervalued. And now we'll go to the next slide. So we've got some guidelines from court decisions. We've got some guidelines from the Iao Standards. That's the International Association of Assessing Officers. We don't have anything in statutes or ordinances, and Juno is actually free to establish what any of these mean. They have not taken up the invitation to. No municipality has, but they are allowed to if they wanted to. But instead, it's kind of left to you folks to decide precisely what each of these terms mean. But we still have some guidelines. Excessive, I'd say the key word, the key idea here on a lot of these is, it's not just a tiny little deviance. Like I said, maybe you would have put a different value on this, but unless you think it's wildly inaccurate, it's not up to you to reverse this. But excessive is significantly different, significantly higher than you think it should be valued. Unequal, I think unequal is interesting. I don't want to steal Mary's thunder, but I noticed she's going to present on the sales ratio of some commercial properties. The reason we have different standards here, and I like to draw the differences between them, is imagine you could show that sales ratios for commercial properties are on average, 70%. So the average commercial property is appraised about 30% below its market value in a given year. Well, imagine you complain that your property is valued at 100% of market value, right? Well, that's not excessive, right? You're coming in here, you're saying I have $1 million property, it's valued at $1 million. It's like, well, what's the problem? Well, you can say, well, every other commercial property is valued around 70% of what it was worth. I should be somewhere around 700,000. So that's unequal without being excessive. Improper is, an improper method of valuation, right? It could be anything from, I can show that the assessor threw darts to determine my value, or something like you use the income method of valuation here when the sales comparison approach was much more appropriate. And we'll talk about, generally the assessor does have the right to choose their method of valuation, but if for some reason it was a residential home and every other residential home was evaluated using the sales comparison approach, and for some reason the assessor used the income approach on this residential home, well, I'd want to hear from the assessor at least, unless the assessor can give a good reason why they changed their method of valuation, that might be grounds for improper. And then undervalue.
Joe, can I ask you a real quick question just before we
Sure.
go past this? This is Kenny Solomon Gross. So unequal, to show that it's unequal. So if you have side-by-side comparable, and I'm just going to go with commercial property because that's what you said, that are on the same block and they're both 5,000 square feet, and one of them during the mass appraisal is valued at $1 million, and the one down the street is valued at next door $700,000. So even if the property is worth $1 million, you're saying that the one that is valued at 700,000 and the one that's valued at $1 million, that one that's valued at $1 million is unequal. So therefore, it would be understandable that the BOE could do some sort of action on that.
I wouldn't want to necessarily talk about one comparable property, but I think my example was more that you could show that all commercial properties were valued somewhere around 70% of what their market value is. And my property is valued at 100% of what its value is. And it should be, to be equal with everyone else, should be somewhere around 70%. So I wouldn't have to show that my property is wildly overvalued. I could show that it's overvalued compared to other similar properties. If in your example, I think that would be a valid argument, is pointing to another property that is almost, it would be, the argument would be over, well, is it really the same, right? Are they both the same property, right? If they are really the same property, I would want, then again, remember, this is about overcoming the burden of proof. So if you establish pretty well that, well, these are the same properties and this one's valued at 700,000 and this one's valued at $1 million, I'd want to hear from the assessor why this one is valued at $1 million when the other one's valued at 700,000. I think that would be a solid argument that would overcome the burden of proof, at least initially. But it could be that, again, this is sort of getting into, these bigger statistics over many different properties, right? I think that's a more powerful argument, is that over many properties, it's all at 70% and mine is at full market value. It could be that that these are kind of, maybe their market value is both 850,000 and one just happens to be 150,000 lower and the other's 150,000 higher. So with just one property to compare, I'd want to see a little more maybe, but that's something for you to evaluate. Okay.
Thank you.
Okay. Yeah, it's interesting. Undervalued. I had doing these presentations, I had been saying, I don't even know why this is on here. Who would ever appeal that? This year, someone in the Kenai Peninsula Borough is wanting their property to be valued at a higher value. So they're appealing on that. So I think they're trying to get a loan or financing or something. But yeah, so it does happen. All right, we talked about this already. It's not in your municipal code, the definition. I don't know, that's not for me to say whether it's wise or not. I'm just saying it is possible for Juno or any municipality to define this. I think it kind of ties the board and the assessor's hands. That would be an argument against this if you were to strictly define what unequal or excessive or improper meant. So, you're not the ones passing ordinances anyway, but it's just good to know. Yeah, the Iao Standards on ratio studies from 2013 provide a lot of good numbers for the sorts of ratios and coefficients of dispersion that you hope to see from different types of markets. So those are good. Those are good sources. Again, you want to see uniformity in the method of valuation. That's pretty standard. All right, this is sort of talking about how the board is made up. You folks have been appointed by the assembly, I believe. It has to be at least 3 members. And I think the you want 3 members at least to hear any given case. So here's your couple of these last 2 get into more of the substantive role of the board. Again, you're there to listen. You're not there to bring your own evidence in. If you see this case ahead of time and you're like, oh, this is interesting, I hope you think it's an interesting case. But you're not supposed to do your own research and not bring in your own sales comparisons or your own ideas. Sometimes people ask me questions during this presentation, anticipating one of the appeals they know they're going to have, and I try to avoid talking about it because that is bringing in evidence. That's, oh, I talked to the state assessor and he said this. Well, that's not really proper. The argument's supposed to be in front of you there, for the assessor to hear and for the appellant to hear the other side. And again, makes the determination based on the facts presented at the hearing. I always thought it was counterintuitive at first until I was asked to think about it a little more during law school. The idea of like, well, wait, if I'm really smart or if I know stuff, right? Isn't that good, right? Shouldn't I, as the judge, be able to use stuff that I know? And the key there is the due process idea, and we're getting a little ahead, but we won't talk about it as much when we get there. But if I have stuff in my head that I think is true, I have a lot of stuff that I think is true and a lot of stuff that I would say I know is true, right? We're not always right about that. If I go home, or not home, but if I make the decision based on something that I think is true, the other side doesn't have the opportunity to rebut that or to say, well, maybe that's true, but it's not relevant in this case. So the key is that each side has to be able to hear the argument of the other side and have an opportunity to rebut it. And if you're going based on secret knowledge that's in your head, that violates the due process of one side or another, or somehow both possibly. So that's why this is important. And I always thought it was kind of counterintuitive until I really thought about it for a while, why this would be the case. So, and I imagine it's counterintuitive for a lot of members of the board. So that's why I really harp on it a lot, is how important it is to not use your private knowledge.
Question. That last bullet, make a determination based upon the facts presented at the hearing. Is that a fact in this context has to be tangible? In other words, is that true? A document, or is something someone says considered a fact?
You'd want, I think you'd want to weigh the credibility of evidence. If someone has a story about a sale that happened on their street and they don't have anything to back it up, that's not very credible. And yeah, and so you don't want to go based on innuendo or rumors, or someone asked me at one of these hearings, was someone built their house and they only spent $100,000 building this house, right? And I said, and it was like, well, how much time do they put into it? How do you know it was 100,000? How do you know it wasn't 200,000? If there's evidence, bring it forward, but you don't want a story about someone building their house for only 100,000 or something, that's a lot less credible. And I'd say, there's no formal rules of evidence here. So if someone has an anecdote that you find incredibly compelling and worth taking into account, that's allowed. But you want to be wise here. And I would avoid taking things like that into account. Is there another question?
Mr. Mackey has his hand raised as well.
Yeah, I'm sorry, my Roomba is going in the background. So I think the key to this, though, isn't it, that if it stays in your head and it's not on the record and it hasn't had an opportunity to be rebutted, that violates due process. But if we use the opportunity of questioning, to bring it to the forefront, to give them that opportunity, then it's not in your head, it's on the public record, and then we can consider that, right? So it's not really, we don't have a role in it, we just can't keep it to ourselves, right?
I would, yeah, you'd want to be careful. I don't think it's really proper to be leading one of the parties or the other party too much. You don't want to, but if you say, you know, that they know something, you know, again, this is sort of thinking about, you know, usually one of the parties is a layperson and they're not going to be experts at articulating their argument in the best way, maybe, right? You know that they know something, right? And they're not saying it. And you might be frustrated and thinking like, if they said this, I would rule in their favor, right? That might be the time for you to gently cross-examine them and ask them a question. Do you have any comparable sales? Maybe, yeah, maybe they forgot to bring up their comparable sales. And you say, you know, there are probably some comparable sales that they would want to show you. You could ask, you know, do you have any comparable sales with you? And then they bring them out and introduce them or whatever. Assuming they've, you know, sort of, we'll talk about evidence and how long it has to be available for the other side to see, but that's just an example of,
right.
You know.
And just to be clear, that's kind of the spirit I'm talking about. I'm not talking about trying to be Perry Mason. I'm talking about more along the lines of asking clarifying questions and things like that to kind of get down to the main point, not necessarily try to make the case for them.
Exactly. Yes. Yes, that's fine. And I would say it's a good thing. Okay.
Yeah,
We're
that
all
was the
set.
last hand, so.
Oh, we got one more?
Nope, that was all.
Okay, great.
Raised. Thank you.
All right. We have a lot of slides at the end here. You see 14 out of 39 probably, but we have a lot of slides at the end that are just appendix. So we're probably more than halfway through. So we've gone over this a lot. We can kind of skip this slide. It's the same thing we've been talking about, and why it might be tempting to use your own facts, because you might know a lot of facts. Hopefully that's why you're on the board. Okay, so again, the appellant is seeking the change of the status quo. You know, the assessors are professional. They've done their work. They put out the values. Now the appellant's saying, hey, you got this one wrong. Well, tell me why you got it wrong. Okay, we've just talked about this as well. We don't have to go over too much, but you want to present, and salient means facts that matter. The example I gave of someone who said, well, what if someone built their house for $100,000 and now the assessor's saying it's worth 400,000, right? Well, you know, how much sweat equity do they put in that, right? The salient fact, it's irrelevant how much they paid for just the materials that went into the house. The question is, what would the house sell for on the open market? You know, that's the definition of value in 2945 110. I believe it's 110. And so that's salient. The amount they paid for materials in the house, not salient. And again, you don't want innuendos, rumors. That's not. I wouldn't say they can't bring that up, and that you absolutely can't take them into account, but they shouldn't be worth much. And that's my advice on that. And you're smart enough to know what value they have. It should be little or not. All right. So here's sort of a list of the tasks the assessor has to do, and here this last one here is the part that where they first intersect with you folks. Is you know, they make a bunch of assessments, they put values on things, and then when people appeal, they defend those values. And a note on this, it's a little bit of an asymmetric situation. I'd say it's not necessarily the role of the assessor to defend all of their assessments. usually before it gets to the board, people will call up and have more of an informal appeal process with the assessor. And sometimes the assessor gets it wrong, and they will change the values when they realize they have something wrong. And so sometimes that happens. Sometimes a fact is brought up that the assessor wasn't aware of, and so their job isn't to cling religiously to the first value they ever put on a property. It's to get it right, not to get it high or get it low or anything. Whereas the person appealing probably wants to get their value as low as possible, because they pay less tax when that happens. Okay. So as I said, if both parties said absolutely nothing, then the assessor wins because the appellant bears the burden of proof. But that shouldn't happen. There's what you can do and what you should do. So regardless, again, this is good practice, and especially if the appellant meets their burden of proof, then the assessor had better do this. Show that there was equal treatment of all taxpayers, that there's uniformity in the values, and that why they used the method they did. Show that, we use this for all hotels, or all restaurants, or all residential properties. Again, part of this is, what's legally right. And then the other part of this is making sure that people feel that they've been treated fairly. Now, there's probably been a lot of conversations between the assessor and the appellant in the past, discussing exactly these things. So if they're not happy yet and they're before the board, they're probably not going to be happy to hear this and satisfied that they are being treated fairly. But it is good for the assessor to make this last attempt to show on the record that they did a good job of this. Okay, and I think this is just an interesting dynamic here, which is that, if I guess depending on the community, but Juno would probably be one of these. There's a certain amount of money that has to be raised via the property tax. If the assessor did a bad job and got everyone's value at 50% of the market value, it wouldn't really matter that much, because what would happen is the mill rate would just double. The mill rate would get multiplied by 2, and then you'd raise the amount of money you need to raise in the property tax. Everyone would pay exactly the same amount of taxes that they would if the assessor had done a great job and everyone was at 100% of market value. To me, the real problem comes in a property tax system when some people are at 50% of market value and other people are at 200% of market value. They might have the same value properties, but one person is paying 4 times as much property tax. So this is that last point between the standards of actual value and uniformity of assessments. Courts generally prefer the latter, meaning courts and me also. I would rather the assessments be uniform than be at the right level. If I had to choose to get one wrong, being at too low of a level is a problem, and that's part of what I monitor as the state assessor. If someone comes in with a 70% sales ratio, I nudge them and say, hey, what's going on here? What are you doing here? Shouldn't you be raising your values? But it doesn't necessarily mean there's unfairness in the property tax system when that happens, as long as the other statistic is the coefficient of dispersion, and that's how far people are from the sales ratio, the sort of the weighted mean sales ratio. And that is an indication of, you're paying more or less taxes than you probably should. Okay. So we've talked about this. Again, this is what the assessor should be explaining. And sort of, again, I don't want to, but sometimes if you've dealt with this a lot, you might feel obvious, but the appellant could meet their burden of proof, right? They could show that, there was something unequal, excessive, improper, undervalued about their assessment, right? They could show there's evidence of this, right? Now they've met their burden of proof. Now it's up to the assessor. It doesn't mean they automatically win though, right? The assessor now can rebut that evidence, right? They could say, you know, there was an improper method of valuation here. I own a residential property, and you used you used the income approach to value my property, and you should have used the sales comparison approach. And I have evidence that you use the sales comparison approach for every other residential property, right? To me, if I were on the Board of Equalization and someone showed that, I'd say, wow, yeah, you showed me that they used an improper method of valuation. Sounds good. And then you turn to the assessor. Well, you don't have to ask them, but the assessor will then present, right? And I would be very interested in why you chose to use the income approach on a residential property when every other residential property is using the sales comparison approach. But you would want to, the assessor would have the opportunity to show that. This last sentence, again, you can't just come in and say, I don't like the value, it's too high, right? Why is it too high? So that should be evident. You know, there should be evidence showing why this is wrong. Okay. So now we're getting into the hearing and sort of the substance of due process in the next couple slides. And again, this is an adjudicative hearing, means sort of right to an impartial judge. That's you folks. So you shouldn't be, you know, looking to get rid of all these for the sake of the assessor because you want the city to save money or something. And you shouldn't be advocates for the little guy who, you know, who's getting screwed by the tax man. That's not what we're looking for here. Again, should be on the record, should be based on the law. And again, we talked about this, should be based on the evidence that's presented at the hearing, not on secret evidence that the party might not have the opportunity, the parties might not have the opportunity to rebut. And you could get reviewed by a higher court. So here are some substantive things about due process. And, you know, there are infinite situations that could come up. And, you know, do your best. I'd say to me that, yeah, the whole concept of due process is, you know, think about, you know, beforehand, if you weren't one of the parties, right, or you didn't know which party you were, what would be fair? It's essentially there should be fairness. So there's some things that we've decided ahead of time constitute fairness, right? So there should be a prior notice of when the hearing is, right? And there should be a hearing period, right? Should be on the record. You should be able to bring someone to articulate your side of things if you want, right? You could bring an attorney if you want. The decision makers, again, should be impartial. And then at the end, there needs to be findings of fact and conclusions of law. And I haven't actually looked at your form, but there's usually a place where you can sort of fill in your findings of fact and conclusions of law. And that both helps on appeals, but it also is a big part of due process. Is that what did you base your decision on? And that helps people at least, it helps people know that, like, it's not, oh, I'm buddies with the assessor and we go golfing all summer together and I wanted them to win. Okay. So here's some specifics on the evidence. Again, it's important that both sides have the opportunity to present evidence. Also that both sides have the opportunity to see the evidence from the other side. And I'd say the classic example that I like to give is sort of, people love to spring last second evidence, think they're going to surprise someone, right? Well, I always tell people, when they call me asking about, well, how can I appeal this or whatever, I tell them, I don't know an assessor in the state who I wouldn't trust to be reasonable. And so if you have evidence, if you have a comparable sale that makes it seem like you're right, show it to the assessor, because I can guarantee you the assessor will be able to tell you why that's wrong, or they'll say, oh, I didn't know about that. I didn't notice that. I'll go back. I'll look. Maybe you'll get your value changed without having to do a Board of Equalization hearing. So that's important. But if you you could imagine sort of an appellant, has a comparable sale. They think they're going to surprise the assessor. Well, if the assessor doesn't have the opportunity to review that comparable sale before the hearing, right? They're not going to be able to analyze it in the 5 minutes or the half hour of the hearing, right? They need to have a week or two. I believe there's usually, especially in larger jurisdictions, there's a set amount of time that evidence has to be given to the board and the other party beforehand. That gives the assessor the opportunity to say, no, that looks like a comparable sale, but it really isn't, and here's why. It makes for a smoother argument that can be had in one hearing. I always, there's the opportunity for either side to waive that right. We do occasionally a training for assessors, and this is similar to this one. It's kind of like how to do appeals. And we encourage them, if you can, agree to admit some evidence, maybe even if you haven't seen it beforehand, if you don't think it will prejudice your case. Because, again, this is not just about what's right and not just about winning, but making people feel like they've been heard and they had an opportunity to be heard. So maybe they're trying to ambush you. Maybe they just didn't think to submit this and they just found this thing, right? This comparable sale that they didn't know about. But they don't have to. The assessor or the other party, I guess, if the assessor is bringing in evidence too late, they don't have to allow it in. It's up to them. But it is possible. If someone brings in a piece of evidence that hasn't been submitted, you can ask the other party, you can say, would you consent to having this allowed in? Or you can say, as the board also say, nope, sorry, period, we're not allowing this in. It's you didn't submit it beforehand, that's what we're doing. So that's that. Let's see where we are here. Okay. Again, we're talking about where I talked about this a little when I talked about the difference between a judge and a jury. Findings of fact or facts about the world. Is that garage attached to the house or is it not? How many square feet? How many square feet is the house? What type of roof does it have? That's a finding of fact. A conclusion of law might be something like this property was valued 30% higher than its market value. Therefore, I'm finding that it is excessive. The fact of what the property was valued at, the fact of what the market value is, that's a fact. The state of it being excessive and therefore sort of reversible or it's time to change the value, that's a conclusion of law. Okay. So we've talked about this a little. Again, think about each case as if it will be appealed to the courts. Courts have a different standard of review in place for facts versus law. Like we talked about earlier, judges are experts on the law. So even more experts than you folks are probably, right? So if you make a mistake on what the law is, they're gonna say, no, sorry, I know the law. I disagree with what you said, Board of Equalization. I'm gonna reverse your conclusion of law. If you make a mistake or if someone claims that you made a mistake on a finding of fact, that's very different. Judges don't have any more expertise than you do on finding facts. And in fact, they know they have less because they weren't in the room. You can read little things like the demeanor of the person making an argument. You had the opportunity to cross-examine them. They were not in the room when those facts were sort of being presented. So when the Board of Equalization makes a decision about a fact, judges and on appeal are very reluctant to reverse that. So they have a much higher standard of review before they will reverse a finding of fact. So, so that's why it's important to get your findings of fact down, because that will make your decision pretty waterproof. You can't, if your decision is based on some facts, it becomes very difficult to overturn, because the court says, well, look, the Board of Equalization found these things, and these things would support this conclusion of law, and they got the law right, and so we're not going to reverse this. Whereas if you make a conclusion of law and you don't find any facts at all, the court doesn't know, right? Maybe you made it based on some very good facts, but you forgot to write them down or something, or just insufficient. The court can say, I can't tell that this conclusion of law was drawn based on something reasonable. They'll reverse and you'll have to do the hearing again. They won't say you got it wrong usually in that circumstance. They'll say, no, you just, you just didn't do your job essentially. Go back, do it again. We'll have to do it all over again. So that's where you want to think about. Imagine you're the court, right? Who's sitting in review of your decision, right? Are they going to be able to figure out why you made the decision that you made? Okay. So again, these are some terms used for standards of review. So substantial evidence means something, right? Was there something to support this fact that the Board of Equalization found to be true, right? There could be conflicting evidence, right? There could be, maybe there's a photo of let's go back to a garage example, right? I'm just trying to think of a random fact, right? Maybe there's a photo of the garage of the property with an attached garage, and another photo of the property with an unattached garage, right? Well, there's evidence on both sides, but there's some evidence for either one, right? So if you as the board made one decision or the other, right, the judge isn't going to second guess you, right? Whereas if there's, 17 photos of an attached garage and, the property owner listed it personally as an attached garage trying to sell their property, and then they come in and they just tell you it was not an attached garage, then that's when the judge might, and you the board decide it was not an attached garage. That's when the judge might say, well, I didn't see any evidence at all, that there was no substantial evidence that this is not an attached garage. Similarly, there's this abuse of discretion, right? You have a lot of leeway in finding facts, but it's possible to go too far. And it's a similar situation where, it was just no reasonable person could have decided this fact is true based on the evidence. Okay. So this kind of gets back to, this is a good example of maybe of due process. And again, there's infinite different situations that could come up where the overall goal is just to be fair to both parties. But the Board of Equalization could allow a late filing. This is not meaning there's a 30-day window after you're notified of value. When I say could, I mean that the state statute doesn't prohibit it. Municipal ordinance might prohibit it. Municipal ordinance might allow it in certain circumstances. An example was in 2019, months after the big earthquake that we had up here in Anchorage, there was a municipal ordinance saying that, damage discovered, kind of after everything melted, but due to the earthquake is considered kind of by default a good reason for not appealing within the 30-day window. So they said, here's why you'd be allowed to appeal late. And that's the important thing here, is that you don't want to be playing favorites with someone. If you allow a late appeal, then why did you not allow someone else's late appeal? You're sort of opening a can of worms. consistency is more important than anything. So this is a good example, a good, specific on late appeals, but also it's a good example of the sort of things you want to be thinking about when you make any decision. Again, we have statutes, but we also have, court cases that sort of put some meat on those statutes. If there's anything uncertain, sometimes there's a court case that could help interpret certain things. So here's some reasons that people give why they want their value reduced. I had someone call me up the other day here in Anchorage complaining about the value of their house, and I had to keep telling them, that's not. They were angry about a homeless problem, right? Well, I said that's not up to the assessor. The assessor's job is to put a value on your property. They're not the ones charging the tax. They're not putting the tax in their pocket. They don't have anything to do with homelessness. They don't have anything to do with a whole bunch of other things that you're probably angry about. So taxes are too high, just someone who doesn't like taxes or has problems with municipal politics. That's not a reason to reduce a value. Value increase too much. Now, this is interesting, right? If they have an argument that their property is not at market value, that's fine, right? The value increased a lot and now I'm not at market value, that's okay. Well, what about last year my property was worth this and now suddenly it's worth 30% more. Well, you got to show that it's not at market value. It's not the change. Sometimes properties increase by 30%. This might be a good year for that, actually. Certain property, there's the housing market's been going crazy. So it might be valid to increase properties by a lot in a given year. Again, not enough services from the municipality. That's not the assessor's problem. That's a political problem. Didn't receive assessment notice. Again, this is a good kind of way to talk about what is the assessors and the Board of Equalization's job versus other things. If people aren't getting their assessment notice, that's kind of my job to enforce that. That there's something called a letter of major error that the Office of the State Assessor could issue, right? But it has nothing to do with whether or not the value is correct. So not receiving the assessment notice is absolutely a problem and it's against statute, but it's not a reason to change a value. Okay. Here's some things to avoid. Don't offer a small reduction in the value because you think, oh, well, you put all this trouble of appealing and coming before us and we should give you a little something, right? Well, you can imagine what incentive that would give everyone, right? Is you'd have 1,000 appeals next year if you gave everyone a small reduction, right? This is something we've talked about a fair amount now. Don't bring in your own comparables, your own evidence, right? It should be presented by one side or the other. If you're considering it as a factor in your decision. Again, don't expect the assessor who's using mass appraisal techniques to bring in the sort of appraisal that you'd see from a fee appraiser. Don't review a case where the question is law, not value. So this might be an example of this might be something like someone thinks they should have received the senior discount or the senior exemption and they didn't, right? And they're not happy about that. Well, that's not up to you. I think legally right now, I'd have to look it up. Legally, the board can hear things like that, but usually municipalities limit the board to value, and that's just a good practice. There might be a regulation, or it might be something that we've been trying to push through as a regulation, clarifying that the board is not supposed to hear that sort of question, exemption questions. But generally, it's not a good practice, and I don't think any boards do it generally. Again, don't, like I said, five different appraisers will, given the same property, will probably come up with 5 different values, and it doesn't mean they're wrong, or one is right, the other 4 are wrong. Those are all valid appraisals probably, right? So until the burden of proof is met, it's not your job to do it, right? Maybe you would have done a slightly different, you would have gone to a slightly different value than the assessor did. But that's not your job unless there's some sort of, you know, excessive, unequal, improper, or undervalued shown that's, you know, more than just a small difference in opinion. Okay. And again, I guess a point to make here. I'm not sure. I didn't make this whole slide deck, the slideshow. This has kind of been compiled over the years. But I guess a point here to think about. It's always important to put yourself back on January 1st, and there's some weirdness there. Kind of weird to say like what was known on January 1st. And I'd say this is valid for both 2020 and 2021, right? January 1st, 2020 was a different world than the one we're in right now. And I'd argue January 1st, 2021 felt a lot different than, say, when a lot of these hearings were being held, the other Board of Equalization hearings, maybe in May, right? In May, it looks like we're going to have a normal summer because COVID cases are plunging. Maybe we're going to get normal tourism back, right? Suddenly, right, things look different. Well, the assessor made their assessment on January 1st, 2021, and that's what they could have known. So it's important to keep that in mind, is that these are assessments made as of a certain date. So that can be important. And similarly here, right, if for some reason it looks like we might be getting another wave of COVID in this country, if for some reason someone comes in and starts arguing that, oh, well, the tourism season is going to die down towards the second half of the summer because of this next wave of COVID, right? That was not known on January 1st. Maybe on January 1st, there was more optimism, right? That, oh, it looks like we're getting the vaccines out, and they work, and COVID numbers have maybe started to go down. So, so this is kind of a strange type of disaster that has been hitting us over the last year and a half. But it kind of plays with that sort of what is known on January 1st issue. Okay. So here's the I like this first one. I'd say is the most important one. Again, I was a law clerk for the Supreme Court of Alaska in 2011. And one of the things they always talked about was, you know, we would get a lot of pro se clients, and sometimes they were handwritten from sovereign citizens claiming that, you know, no one can charge them money because they write their name in all caps or something insane like that, right? Well, it doesn't matter. They're one of the parties, and our decision was respectful to them, and it answered their claims. They said something crazy was true. We told them why it was not true in plain English, not condescending. There's a lot of angry people appeal their property valuation, and they might not have a very good case sometimes, but you owe them your attention. They've appealed. You're an important step in the process, and maybe you're never going to make them happy, especially if they're going to lose. But it is important that you show them respect, and I'd say that's an important thing to always keep in mind, right? And then these other things are things we've talked about, so I won't go over them too much. So this is the summary. And we've talked about these, so just have this on hand, review it. And thank you for your time. I'm happy to take any questions.
Mr. Casey, or is it Casey?
Yep.
Okay.
It's Casey. Yep.
You might want to stop sharing your screen so you can see hands. They come up.
I have a question.
Okay.
You spoke earlier about someone, we're having a hearing and someone comes in with an appraisal. And let's say we're having a hearing next month and the appraisal is dated in May. Well, we really can't do anything with that because it's after the 1st of January, correct?
I wouldn't say you can't do anything with that. I would say it's evidence. If I were if I were the assessor, and it were important, if something had changed, say between January 1st and May, that would be a tool I use to attack that piece of evidence and say, that assessment is as of May 1st, and here's what changed between January 1st and May 1st. If that's not relevant, if not much has changed between January 1st and May 1st, the assessor probably won't bring that up. There might be other problems with it. But I'd say 5 months isn't that long in normal circumstances. So it's absolutely something you could consider. But if for some reason those 5 months were important, then you'd also want to consider that.
We always used to answer that with, well, that counts for next year. It doesn't really affect this year. I'm bringing this up as a timeliness issue, not so much as a, well, it looks like things changed issue.
I'd say if the assessment is based on on basically mostly only facts that would have been known as of January 1st, it could count for this year. I think that would be fine. But if something changed though, then it's saying no, next January 1st, this will matter. But I'm trying to think of an example. I mean, people constantly are coming to me about, I just turned 65. I'm 65 now. Don't I get my senior exemption? And I say, yes, you get it next year. You don't get it this year. But it's similar to that. If something definitely changed with the property, then but after January 1st, no, that's for next year. But if it's an appraisal of the same property, and now there's nothing new about it since January 1st, that's a valid piece of evidence that I would look at.
This is Barb Scheinberg. I have a question, just kind of an affirmation of something that we've done in the past. People bring in evidence and all the time for us to consider the night of the hearing. And sometimes it's things that the assessor can look at on the fly and respond to, and same for us. But sometimes it's just like complicated. Well, we didn't have this and we're not sure. And so sometimes we'll say, we want you to come back at our next hearing because the assessor needs time to think about this. I mean, you've presented some stuff that needs more than just a quick response. And I guess I just want you to affirm that, sometimes that's what you do.
Yeah, I would agree with that. And I would also say, again, it's not up to you with that first scenario you laid out. It is up to the assessor, or if for some reason the assessor were to bring their own evidence the night before, right? It's up to the appellant, the other side that could be disadvantaged, to say, okay, that's all right. Bring in this evidence that I didn't get a chance to review for long enough. Because I believe your Board of Equalization probably has a fixed amount of time, a standard that you have to meet in terms of getting the evidence in ahead of time. And so if you're going to go with a variation of that, it's up to the other side to say, I am okay with letting this in. But your second part, absolutely, yeah, you should do that. Say, sorry, You didn't get it in time. If you want this to be part of the hearing, we're going to have a hearing later.
I'm going to chime in. I think that that's part of what our assessor staff and the city attorney staff is going to be covering in their part of the presentation tonight as well.
Great. Yeah, we should probably wait and see what you're covering.
Yeah. And again, if I say something and they say something different, feel free to contact me and ask for a clarification afterwards, or if for some reason you thought something was going to be covered and it doesn't get covered, I'm always available. That's kind of my job as the state assessor, to be here to answer questions like that. So.
Well, thank you, Mr. Casey. Appreciate your being here again. Last call for questions for the state assessor. Hearing none, we'll move on to the CBJ Law Department for their piece of the action.
Mr. Epstein, I think we were going to have the assessors do their presentation next, followed by the law department. Is that correct, Ms. Hammond?
Yes, that's what we'd like to do.
Fine, I'm sorry. Go ahead.
Thank you. And we'll have Michael Dahle as the deputy assessor for this city, and he will be presenting today. He's got a slideshow that he's going to share.
Okay, so I'll do a screen share. And adjust my screens a little bit. Okay, well, good evening, and thank you for attending this training session. During my part, I hope to give you a little background on how the assessment system works, on the analysis that we did for this year, and on this year's assessed values and the work we did at arriving at those assessed values. So we'll start with just some assessment basics. As mentioned, we're required to determine a fair market value for each property. And the assessed values are critical to the equitable distribution of the tax burden. So the uniformity was mentioned in the state assessor's presentation, and we will hit on that a few times during my presentation as well. Values are set as of January 1st of each year. There's three approaches to value that are considered: the cost approach, the sales comparison approach, and the income approach. Generally speaking, we use a market or sales comparison approach. That's especially true for the residential properties. When you get into the commercial properties, you do sometimes get a cost approach or the income approach applied as an alternate or preferred alternate. So usually the preferred approach is selected for a particular property class and then is applied across that entire class of properties. We use a computer-assisted mass appraisal system, which is called a CAMA. So typically the underlying value is determined from a base rate. It could be a price per square foot, or it could be a front foot, or it could be a site value. There's different ways of doing it, but based on some base rate, an underlying value is achieved. And then adjustments are made for various factors that apply to that individual property. Then the improvement value takes into account the size of the buildings, the age, the construction method, the quality, the condition, and other enhancing features of the property and improvements. Then the land and improvements are reviewed for adjustment annually based on a comparison to sales, and that's done primarily through this ratio study process. So as a general rule, Basically, the land value is determined first, and then the building values, and then that's reconciled to where the market's at. So let's look a little bit about property values. Regardless of the purpose of the value or where it's coming from, it's based on some kind of model. And we utilize valuation models in our work. So it could be a formal one put to paper. Of course, I have to paper in quotes because today it's usually not paper, it's actually just put into a computer system. Or it could be some informal model that someone just has in their head. So an example would be if you and your neighbor are talking about a house down the street, you may each have your own model that you use, and one of you may feel that that house would probably sell for $350,000, and the other one may feel that it'd sell for $400,000. And each one of you has a perspective that you're applying in coming up with that value. Realtors will use some kind of model, and that goes through a broad range depending on the realtor. Some realtors might use a very simple model. Other realtors might get more involved and use more adjustments. But they're applying some kind of model. An appraiser, he applies a model, and that model is usually a little bit more defined because an appraiser is working under certain guidelines and standards that he has to adhere to. adhere to. Another example would be an insurance agent. They're typically, the ones that I've seen, they're using a cost approach because they're specifically interested in how much is it going to cost me to rebuild this structure. So all different models can range from something simple to something very complex. In the property valuation process, in establishing that model, there's basically two primary steps. One is called the model specification. And in the model specification, you're determining what attributes or property characteristics affect value. The second step then is called model calibration. In the calibration step, you're determining how much effect each of those attributes have on value. So the specification is which characteristics, and the calibration is how much of an adjustment for those characteristics. We do have an objective of moving the commercial properties more fully into the CAMA system and utilizing mass appraisal in the CAMA system. Currently, they're not fully implemented in our CAMA system. We do use mass appraisal as the primary means of achieving values. There are occasional exceptions to that, but that's the predominant method used for most of the values. That's very standard for assessment valuations and is what you'll most commonly find. I'd like to give a little comparison of a mass appraisal versus a single or fee appraisal. And the way I like to look at it as a comparison is one is a vertical process and the other is a horizontal process. So in the fee appraisal or single appraisal approach, it's looking at each step of the process for one particular property. And you're going through all of the steps for that one particular property, and you arrive at a value, you finish that appraisal, you go to the next one, and you start back at the top and you work all the way down through the steps in order again. Mass appraisal, you're doing each step one at a time for all of the properties. So for instance, you might establish all of the data. You'll do all the data collection and establish the characteristics of all of the properties. You'll do the analysis and establish what the market level is for all of the properties. And then you apply each of those steps down through the valuation for all of the properties at a time for each step. So one process is going through each of the steps for one property. The other process is going through each step for all of the properties. So it uses the same principles and the same practices, but it's a different workflow between the single fee appraisal and the mass appraisal process. Potentially, the mass appraisal process gives you more uniformity because you're dealing with applying your conclusions to all the properties at one time and then through one process. So another key component of arriving at assessed values is the analysis of the market and the analysis of the assessed values. And our analysis is multifaceted. There's many aspects to it. We'll just highlight some of that real quickly. We look at general market conditions and trends. So what's going on with the market? We look at utilized ratio state studies, and those are looking at our assessed values compared to where the market is and what adjustments we need to make in order to make our assessed values reflect the market. We do special studies, things like paired sales analysis or other special studies, and they can be very critical, and they can have a lot of variety as to what they're approaching. So a lot in that one line is, there's a lot of different special studies that can be done. In doing an analysis, the information that we look at includes sales prices, construction costs that are used in the cost approach, income and expense trends and how they're affecting the income approach, lease rates also used in the income approach, and the capitalization rate is used in the income approach. We also look at all of the financing and financial market information because that has an effect on the real estate market. And so how is financing changing? What's the availability? Those kinds of questions. Within that analysis, we mentioned the sales prices. For the sales, we primarily use the last year, the previous year of sales. However, for property types with fewer sales, or in order to analyze subgroups or subclasses of properties, the number of years of sales can be increased. Generally, it's usually increased a year at a time back up to as many as 5 years to arrive at a large enough sample size. For special studies, sometimes it'll go back further, like a paired sales study. You may go back 10 years in order to have enough time frame for those paired sales. Then within the analysis process, what I refer to as the Juno challenge is one of the things that we consider. We are a somewhat isolated market with a limited number of commercial properties available and a fairly low number of sales. At the same time, things that go on a statewide basis and a national basis do affect our market. So we're not totally isolated. There's a mix there between being isolated and yet also being affected by those larger markets. Up until this last year, there was no requirement for sales prices to be disclosed. And so besides starting with a low number of sales, we only had data on a portion of those. So sometimes the data that we have to work with is fairly limited even in an active market. Regardless of those challenges, each year by state statute, we have to set the assessed values. And so even if there isn't a lot of data, we have to work with what we have in order to set values for that year. Looking at our staff, we have an assessment clerk that provides taxpayer services, handles administrative tasks. We have a business personal property appraiser who specializes in the business personal property valuations and also in the manufactured home valuations. We have 3 certified staff appraisers who primarily work on residential values, but they may also assist with the commercial valuations. We have a deputy assessor, myself, who is a primary commercial appraiser, and we have the assessor who oversees the office and the valuation process. Then before we look at some of the specifics of the valuations, a couple areas I'd like to touch on. One would be external appraisals. And I want to touch on this because it's often a bit misunderstood. First of all, we welcome the submission of external appraisals. And by external appraisal, what I'm referring to is an appraisal done by an appraiser outside of our office. And outside of the assessment process. We welcome them because reviewing them can be a wealth of information. Sometimes a person doing a fee appraisal has much better access to that property or to what's going on with the property or to the business specifics. And so there may be information that they're aware of that we weren't aware of. And so it can be very informative to have access to one. Sometimes it can, based on that information that we weren't aware of, when we become aware of it, we actually make a change to the valuations. So that does occur. Appraisal becomes available to us, we review it, and from that information, we actually change the valuation. However, the other side of the coin is that those valuations, those opinions of value, are not directly applicable to the assessed values. Typically, they are performed for other purposes, and they also may be performed with other valuation dates. And so those things need to be taken into account when you're looking at them. And when looking at external appraisals, that is a separate individual's opinion of value. And an example would be that there was a lot out in the valley which had good comparables, and the owner recently had appraisals done on it to determine the value of it, and it had 3 different appraisers do up a value, and their conclusions of value varied by as much as 40%. So each one is an individual opinion of value. And one of the very important things for assessed values is that uniformity. And so because that uniformity is paramount, we don't just take the external appraisal value and make it the assessed value, because those assessed values are used to calculate individual tax burdens. And so the uniformity aspect is very critical within that. So another thing I'd like to look at is COVID-19. We've had an unusual couple of years, year and a half, and I basically have 2 comments on that. And the first is that we recognize and are sympathetic to the fact that this past year has been a very difficult year for some businesses. Some businesses saw drastic reductions in revenue. Some saw, if they were tourist related, almost a total elimination of revenue. At the same time, this last year was a very good year for some businesses. Some businesses actually had record-setting years in 2020. So we're in kind of a unique position. While we're aware of the financial struggles of some businesses. In the midst of that, what the state statute says we have to do is we have to determine the market value of the real estate. And while a particular business may be going out of business, the underlying real estate still has value. And that value, depending on what's going on in the market, may decrease, it may stay the same, or it may even increase while this business is failing. And our task is to determine the value of the real estate, the real property. So next, let's look at some property characteristics that affect value. There's many, many factors, and we'll only hit a few of them here, but this will give you kind of a little bit of a background of what we look at as we set values. Some of the key factors are the class of property. Another one is property attributes or characteristics. And a third one is the property location. And those are pretty much three primary key factors. So let's look a little bit at each of those property classes. We have two major classifications, residential and commercial. Within the residential, we have subclasses, things like single-family residence, a residence with an apartment, multiple improvements, that's a property that has more than one house on it. We have zero lot lines, condos and townhouses, plexes, duplexes, triplexes, fourplexes, etc. And we have manufactured homes. And so we look at each of those as a subclass that gets analyzed as far as the assessed values in the market. Within commercial, we have a lot of subclasses as well. A few of them are retail, office buildings, medical facilities, hotels, industrial buildings, and there's numerous other classes as well. So those are some of the subclasses within the property classification of residential and commercial. Next part that we'll look at is the property characteristics or attributes. Typical things that will affect value are things like topography, a view, having waterfront, the access to the property, whether the property has wetlands or flood zones. And these things aren't necessarily automatic deductions, but they may, or additions, they may include maybe worth looking at. So for instance, wetlands on a particular property, if it's an agricultural property and it's a river and the river floods every year and supplies new soil and nutrition to the agricultural property, that flood zone may not actually decrease the value of it. On the other hand, if it's a piece of property where somebody's trying to put in a subdivision, that flood zone may affect what they can do and how many houses they can put in. So a lot of complexities in the attributes, but they definitely have an effect on value. And the list is much longer, but that gives you an idea of the property attributes. The next thing we talked about was location. And this map, the different colors show you different neighborhood designations. And so we have neighborhoods designated both for the residential properties and for the commercial properties. And another term that's used for neighborhoods is market areas. And we're looking at refining what we're doing with neighborhoods a little bit and establishing market areas that have regions and districts as well as the neighborhoods, so that as we have different amounts of data, we can zoom in or expand out depending on what's needed to get a proper data set to look at a subset of properties. So we have locational adjustments that are applied both to residential properties and to commercial properties as well. Next, let's talk about the market. The market sounds simple, right? Singular. Let's talk about the market. Well, In actuality, the market is a mixture of influences and perspectives of the many people and entities involved in the Juno real estate market. So an example I'll use to try and illustrate that is about a year ago, there was a house that came on the market. It was advertised individually by the owner on Craigslist. And I saw it and I called him the day after it was listed. And he said, well, it's sold. I was not surprised because the price was very low. And I was looking at buying a home, and that's why I called him. So I talked to him a little bit and found out, well, he had already left town. He had moved south. This property had an apartment in it, and he wasn't there to keep an eye on it, and he wasn't there to do maintenance on it. And he just felt that was too much of a risk, having a house with a tenant in it where he wasn't there to do the maintenance things. And so he put it on the market at a very low price because he knew it would sell quickly and he'd be done with it. That's part of the market. It was a willing buyer and seller, but there were circumstances that caused it to represent not the core of the market, but a low end. Another example would be if a couple decided that it's probably about time to move to Arizona and not be in all of the rain and cloudy weather, and they decide to put their house on the market, but they want to maximize what they get. They don't have to move quickly. And so they put it at a high price, what's sometimes called a make me move price. Well, they're going to be at the upper end of the market. They're willing to wait 3-4 months if they have to get an offer. So the market is very complex and driven by lots of different perspectives and life situations. And we try to reflect that in our valuation models. So one of the things we look at is sales volume. And so looking at the sales volume for this last year, in the commercial properties, the sales volume held steady throughout 2020. What we were looking for was there was, a drop off in the sales, if the sales just totally dried up. But in fact, they held steady through 2020. In the residential properties, I put in here the phrase "it remained strong." That's probably an underestimate. The days on market in residential is down to just 1 or 2 days for an average days on market. So the residential is kind of crazy. Sales prices, we specifically looked at those, and even though we used 3 years for the residential and 5 years for the commercial, we also looked at, okay, what does this last year indicate? Especially looked at it extensively in the commercial end because we wanted to make sure that if there was any kind of drop off on the market from COVID-19, that we were picking that up. And there was no indication of any drop off in the sales prices in the commercial properties. So the residential properties continued to increase, commercial prices held steady. Part of that may be because Juno just has such a limited supply of properties. And so when you have more demand than you have supply, that tends to keep the market strong. This is a chart that shows the commercial property sales, and I would focus here on the last 3 years. And the orange line up here is the total number of commercial sales that look to us to be market sales. They weren't a transfer within a corporation. They wasn't a relationship between the buyer and the seller. They look like a market sale. This lower line here, these are the number of sales that we actually had price information on. So these are the sales that we actually could do analysis off of. And you can see that we don't get prices on every single sale. And so we're limited in what we have to work with in analyzing the market. So quick overview of what residential properties and values saw. There's a lot of information here, but let's just focus here on the mean and the median. You can see that for residential properties, we started at about 96%. After applying this year's adjustments, we ended up at about 98% for residential properties. You can also see that we have in the oh, I'm forgetting the name of the graph all of a sudden. Scatter diagram. So you can see that we have quite a few sales to work with on the residential side. When we go to the commercial side, it's a little different picture, far fewer sales. But you can see that we started at about 70%. After making the adjustments for this year, we ended up around 85%. The median's about 88, but there's a little bit of skewing in the sample, so the median would be less reliable and the mean would be more reliable. So basically we ended up about 85%.
Question.
Yeah.
What does, could you explain the term COD, please?
COD, can I answer that in a second? I'll get into another graph that has that.
Of course, thank you.
Okay. So one of the things that occurred this year is we had to make some corrections to the commercial assessments. So as we looked at, they were at about 70% of the market. If you look at just the vacant commercial land, so not improved properties, but commercial land, that was down around 40% of market, while the residential properties were at 98%. And so some adjustments we made a 50% increase to the base commercial land values. And so that's basically a factor of 1.5 was applied. And the reason for doing it to the land is that all commercial properties have the land. So by applying it to land, we were able to lift all of the values up uniformly and keep the land values between vacant and improved uniform and consistent. One class of properties that's a little bit different are called warehouse condos. And typically those are derived off of market sales, and the land isn't separated out. And so in the CAMA system, there's just a token land amount, like maybe $5,000. But the real test of the value is the total valuation. And so those received a 20% increase on the building portion. And that 20% is similar to when you apply that 50% land adjustment, what that meant overall for commercial properties was a 20% increase. So the warehouse condos got that same 20%. A class of properties is quite different, but falls within the commercial property classification is boat shelters or boat houses. And actually analyzing those were above market. And so they actually saw a 20% decrease to their values. So as a result, we ended up at about 85% of market. So we're about 10% low still on them, roughly.
Quick question.
Pardon?
Quick question. May I ask a question, please?
Yeah.
What's the difference between a warehouse condo and a boat shelter? I'm not understanding.
The boat shelter is the floating boathouse on the water that people pull their boats into.
Thank you.
Yep. And yeah, some of the terminology working on refining.
Mr. Dahle, may I ask, I have several questions, but I would like to, I think, wait till the end of the presentation. Roughly how many more slides are there? I'm just trying to think of what to do here.
I'm on 22 of 36.
Okay, I'll just wait. Thanks.
Okay. So a little bit more background on the commercial values. They had not, most of them had not changed for 10 or more years. And so they had not kept up with the increasing market values. And so we were having to make an adjustment for a number of years worth of market change. And some of the reasons it didn't change for 10 years, probably some of what we've covered. There was a CAMA conversion in there. Certainly the Juno challenges and some other factors. What that caused was the assessed commercial value assessments to lag behind the market. That causes a tax shift, which shifts some of the tax burden from one party to another, in this case, from the commercial properties onto the residential properties. So when that was identified, it needed to be corrected. And so we made the adjustments to this year. This is a chart that just illustrates that. The blue line is the residential properties over the last 8 years. You can see they're continually increasing. This orange or reddish line is the commercial properties, and you can see there wasn't much change. Gray line at the bottom is vacant land, and no change within that either. So a lot of work was done this year cleaning up the commercial sales data. Still a lot more work to do, but we made a lot of progress. From that, we ended up with 57 sales to use in analyzing the market from the last 5 years. And I'm going to jump back here for 1 second. The next slides I'm going to get into. In our analysis, there's a lot of statistical aspects to it. And so this is the kind of point where for some people, the eyes are going to glaze over. So I'm not going to go in real depth in this, but I just want you to see that there is a lot of depth of what we do in the analysis. And so I'll point out a few things. And if any of you have questions, I'm happy at some time to go through this in more detail with you. But this is just a quick snapshot. This is a snapshot of some of the statistics based on our beginning point. So this is where we started. It does not include the condo warehouses. So for this sample set, there was 54 involved. The mean and median, you can see, are right around that 70%, 69 for the mean, 73 for the median. And we're looking at a whole lot of things here. The kurtosis, the skewness, sample distribution. Is a sample representative of the population? What's the PRD? Is the model regressive or progressive? And so there's a lot involved in here. And this is where you'll notice that that COD crops up again. COD is your coefficient of dispersion. And these are measurements, the COD and the COV, are measurements of central tendency, or how uniform your values are. And so the lower a number, the better. And 23 isn't great, but it's not bad considering that this sample includes all of the subclasses of commercial property and includes commercial land as well as improved properties. And the more of a mix you have, the more of a higher COD you're likely to have. The graphs that go with this, this is a Whisker plot, and it tells us important information. The box is the interquartile range. You've got a scatter diagram that tells you something different. And you have a histogram, which also gives you. So we have different graphs, different charts, and they each give us different information on what's going on. So this set is after we made our adjustments. And you'll notice now the mean's up around 85. The COD improved. It went from 23 something down to 21, a couple of points of improvement. So that was very encouraging that with the adjustments we made a couple points worth of improvement in the COD. Looking at the graphs and charts, the interquartile range got a little bit tighter. We almost got to a more standard distribution, a little bit more of a bell curve shape here. So those are things that are good indicators as to what we did. The next chart, I think is probably the most critical of them. The left-hand side shows where we started, and the right-hand side shows where we ended up. And so this blue line is the residential level of assessment. This orange line is the commercial improved properties. The red line is commercial overall, meaning it includes both improved and the land. And then the gray is the land. And you can see the land still has a ways to go, but we certainly brought the commercial improved properties closer to a uniformity of assessment level. So I would say if you can capture what this chart represents, you'll have captured the essence of what we did this year in making changes to commercial properties. So over the next few years, we're going to work on bringing more uniformity between the commercial and residential property classes, more uniformity within the subclasses, correct the imbalance on the commercial land between the land component and the building component. This year is just a first step. And so we applied the adjustments mostly to the land component. Next year, we'll see a lot more adjustment to the improvement or building models and valuations. And hopefully we'll bring all the commercial properties closer to market. So we've kind of reviewed this. 50% increase to land was for most of the commercial properties. Overall, that increases, it results in a 20% increase. Each property is going to be different because of the mix between land value and building value. So everybody's going to be different, but that's what it came to overall. So future refinements coming to all of the subclasses. We'll be refining the location adjustments and the adjustments for things like quality and condition. So the last little bits to focus on are, gee, what's upcoming? Well, the appeal hearings. And just to give you another overview of how this whole system works, the property owner fills out a petition for review. In response to that petition for review, we, the assessor's office staff, review the individual property's valuation. So again, we're using a mass appraisal to determine the values. In the review process, we're able to focus down on that one property and look a little bit closer at that one property. If we find something that we weren't aware of, a condition in the property or something else that warrants a change, we will work up a new value. We will present that to the property owner. And if that's agreeable to them, it's resolved right at that level. It becomes an administrative correction. Excuse me, we make the correction. It's over and completed, and you guys never even see it. If what we come up with, the property owner still doesn't agree with, and they want to turn it into a formal appeal, then that review transitions into a formal appeal, and we help them in bringing that then to you guys for review. So what you see, when we do the reviews, we correct errors we find. What's coming to you is only a portion of what started out in the petitions for review. And so you're reviewing the ones that became a formal appeal. Again, as we're going through the review, we keep the issue of uniformity very much in our mind. We don't want to treat somebody differently or take them out of uniformity for reasons of distribution of the taxes. And I encourage you guys to keep the uniformity aspect in mind as you go through the hearings as well. One last thing I'd like to touch on is cap rates. In the commercial property appeals, it's likely that we will have some that use the income approach. And a key aspect to the income approach is called the cap rate. And in my purchasing of commercial properties in a previous life in Southeast Alaska, I had my model that I worked from. I had my criteria, my benchmarks that a property had to meet for me to consider it. I had other people, friends that were involved in commercial property purchases. They had a separate different set of criteria. They needed a different level of return than I did, maybe higher, maybe lower. They had different perspectives of what they were looking at, and that's perfectly legitimate. Within a market, you're going to have different viewpoints, different things that people need. So as we're looking with the cap rates, again, uniformity is critical. And so other individuals can choose a different cap rate, and that's certainly appropriate for their purposes. But when we're applying a cap rate to the income model for all of the commercial properties, we have to be uniform in what we're applying in order to maintain the uniformity of the assessments. So we've selected a cap rate, and we've attempted to be very conservative in selecting the cap rate. And one thing to keep in mind with a cap rate is if you have a particular property and you have the income stable, it's not changing. If the cap rate goes down, the value of the property goes up. So a cap rate and the value are an inverse relationship. As the cap rate goes down, the value of the property goes up. With that in mind, with the data we have available, some people argue that Juno should have a very different cap rate than anywhere else, and we have not found support for that in the data that we've seen so far. One caveat to all of that is as we work through all of these reviews, it's possible that at some point in this process, some information comes to light and we change our analysis, our view of what the cap rate should be. But currently, what we're seeing is that an appropriate cap rate is 6% overall and 7% for hotels and motels. And that's based on a lot of research, and I'll go through a sampling of that just real quick. But I'm not going to dwell on this much, but just some samples. Cap rate for Seattle, Class A in the Central Business District, 4.75 to 5.5. Cap rate in Class A suburban office rates, 5.75 to 6.5, kind of bracketing our 6 point. 4.25 to 4.75 for Seattle multifamily. 4.75 to 5.25 for Seattle multifamily suburban rates. 3.75 to 4.25 for Seattle Class A industrial rates. 4 to 5.25 for the 2021 US real estate market nationwide. Anchorage, 5.96 for 1 to 3 floor apartments. Pierce County for 1 to 3 or 4 apartments is lower than Anchorage, 5.01. Ada County, Idaho, 5.27 for the same. Seattle multifamily combined Class A and B mid to high rise, 4.88 to 5.26. Seattle retail class, both A and B combined, 5.36 to 5.76. 5.67 to 5.87 for Seattle office Class A and B combined. Industrial Class A and B combined, 6.12 to 6.13. So that's just a smattering of examples of rates. So thank you for your attention, and we can do questions, and I can either remain on the slides if we need to go back to something, or I can stop the screen sharing, either way.
Can you stop the screen sharing for now?
Okay.
I have one question related to a slide.
Okay, well, let me stop the screen sharing, and if we need to go back to it, we will. Okay, so there we go.
Well, if I may, The one question I had that was about a slide was the slide that you had with the 4 color graphs, and you said this is the most important thing to me, and it had the residential, the commercial, only the land, and the 4
Right.
different colors. Can you go back to that?
I can,
Thanks.
and I'm back there now, so let me share that. Oh, it didn't go back there. There we are.
There. Yeah, thank you. So I just wanted to understand, make sure I understood, because I'm not sure I do. This chart shows the ratios based on the assessment year 2020, the starting ratio, and the results of our adjustments for the assessment year 2021 ending ratio. The ratio of what to what?
So this is the ratio of the assessed values compared to actual sales prices of properties.
Okay, that's what I wanted to make sure. That was my assumption, but I wasn't quite
Yeah.
sure. So,
And
okay.
so starting ratio, that's where we started this year,
Mhm.
looking at the assessed values from last year.
Yeah,
Assessment year 2020 compared to where the market was now in 2021.
yeah.
And then the new ratios with our adjustments
Okay.
compared to the market.
Okay, I really appreciate that.
Sure.
So my other couple of questions that I had were, so based on this presentation, I can really guess that many of our appeals will be from commercial properties this year.
Yes.
And that's kind of what I've been hearing through the grapevine. So I'm not surprised now that I've had this presentation. And I guess one question I had is why had we really not looked at, why had there been no change for 10 years? I know with residential properties, we try and hit everything at least once every 5 years, if not before. Why did we not have any change for 10 years? How do we talk about that?
Well, I will give my answer to that. And it's critical that you understand that I've only been back in Juno for 1.5 years in this position. So why are we making the corrections? Well, we're making the corrections because we discovered the discrepancy. And state statutes say that all of the classes have to be assessed at the same level. Why they weren't changed over the 10 years, and I don't know if I'm still there. Okay, I had a pop-up that made everything go away, so I wasn't sure I was still connected. I can only go off of what I suspect. And I suspect part of it was probably the Juno challenge. We don't have a lot of sales. And I've got a lot of experience. I've got over 20 years of experience in the assessment profession. And I spent a number of years providing consultation to all 46 counties of Washington state. And within those, you have things like Wahkiakum County that has 4,000 parcels. You have other counties, Asotin County, that has very few parcels. So you have situations that I've been dealing with for years in how to evaluate markets in situations where you have limited amount of data. But if you don't have a lot of experience in that, you may make the decision that, well, I think values are increasing, but I'm just not confident enough to make that change. And it just accumulated enough over the years to where I'm looking at it and saying, we have to make a change because we are definitely below market.
So I think you had an excellent presentation, and I really appreciated that, much more detail than we've had on commercial assessments and whatnot in the past. I guess I'm wondering, have you given this presentation, I mean, this is sort of off BOE topic, but like realtors get together and has the assembly seen this? I'm just wondering, because I'm sort of going, gosh, we're playing a 10-year catch up here. Should we be amortizing this out over 3 years? I just have, they're probably policy level questions, not really BOE questions, but I'm imagining that we're going to be hearing these kinds of things. And I just wonder, are the people, the appellants, are the commercial realtors, are they getting the benefit of the presentation that we just had to help people understand what's going on here and why are we seeing this all this year?
Yeah, the finance director made presentations to the assembly, also made presentations to various business groups. Certainly there's always more that we can do in the area of education. And we hope to increase the public relations aspects of the office as we go forward. But yes, presentations have been made. We put two summarizations of this onto the website as assessed values were going out, so people could download it and read it on their own time. And so various things have been done to try and get the word out, but you certainly had a large group of people. We have, I think it's just under 2,000 commercial properties. And so you had a large group of people that have gotten used to, for 10 years, not seeing any change. As far as why not do this over 3 years, state statutes doesn't give us that option. It says that you shall assess people at an equitable value. And so when I find the error, I have to correct it.
Well, will we get a copy of this presentation? I assume yes.
It was emailed out
okay, I missed that.
yesterday
Thanks.
or this morning. I don't remember which it was.
Okay, and
I think
with
it was
the
yesterday.
Thanks. With the board's indulgence, one last, just a comment, and then I'll stop. And that is, you know, when we get, this is a general comment, when we get cases presented to us, of course, we're all doing our homework, looking at everything we get and making sure we understand it and looking at the comparables and, you know, those matrices that we get that have, you know, the wetlands and the slope and all the different factors that add to and decrease from the neighborhood value and all of that stuff. Sometimes, especially with the first packets, like we don't get all the information we need, or things aren't labeled, so we don't, it's like we get a reference to a neighborhood in the packet and then we can't find it. And so I guess I'm just urging, just a general comment, when you guys prepare your packets for us, just remember that, you know, put your hat on of like, we're lay people and we don't know this stuff, and like, wait, what does that abbreviation stand for? The more you can help us, the better, because it's often that we just don't quite have all the pieces to reenact in our minds what the assessor went through. And it seems like that's part of our due diligence, especially if somebody's appealing it, is to just make sure we see what's happening. So that's my comment.
Yeah,
Just,
and that's noted, and we've had discussions around that to
thank you so much.
try to simplify things as much as possible.
Thank you.
Yep.
Annie, you want to go next? Unmute yourself first. There you go.
Sure. Thank you, Mr. Chair. Appreciate it very much. Michael, thank you very much for your presentation. I've got a couple of things that Barbara touched on, and I just kind of want to expand on that. First of all, I know that, like she said, through the grapevine and the word on the street is we're definitely going to have a lot more commercial appeals this year. And I hope that in the past, over the several years I've been on this board, sometimes I just want to make sure, Michael, that you're ready to defend all of your actions very well, and explaining that to to us and of course to the appellate to make sure that we're all on the same page and that we're able to do this. I, like Barbara, did not get the slide deck or at least see the slide deck. And I always like to review everything before I go into a meeting. I did go back into my email and I did see that it did come, but I would really like it very much, Michael, if you could send this slide deck back out to the board. And if you could put some narratives on each slide for us, just kind of explaining a little bit to us so I can go back and review this before we go into this. And like Barbara said, this was a very in-depth, way more than we've ever had, at least since I've been on this board for, I don't know, 5 or 6 years of the commercial aspect of it. And I know that's a lot to ask of you, but it would really help us while we're making these, listening to these appeals.
Can I ask what kind of notes would be helpful in there?
Well, I would just like a short narrative of each slide, like you did when you went and talked to us. Like the COD and just kind of the abbreviation and just, I know David asked that question and we waited like 3 or 4 slides before we went and explained it. And, I think I understand it, but I'm not 100% sure. And I've seen a lot of this stuff, so I just kind of some stuff like that. Explain your graphs and what did you call those multi-dot graphs or
Scatter diagram.
Your scattered diagrams, which is great. When you said that, I understood that more. But if we could get something, a little bit more like that.
Okay. Could I make a quick comment on the COD and COV?
Absolutely, please.
The distinction of those two versus a lot of the other statistics is that those are by formula put into a percentage. So you can actually compare that data, that statistical information between one set of data and another. So if I told you that there's a 5-cent price difference, is that significant or not? Well, if I'm talking about penny candy, that's significant. If I'm talking about an automobile, that 5 cent is nothing. So what the COD and COV do is they give you a number that you can compare across different sets of data. So I can look at one set and see a COD of 15, and I look at another set of data and see a COD of 18. That's a comparative that I can compare one set of data's uniformity to the other.
So in my lay brain, that would say that there's a 3% difference. Is that significant or not?
Well, that's where it gets into interpretation and what are you dealing with?
Right. Whether it's penny candy or whether it's,
right. But it at least gives you a comparative statistic that you can compare across data sets. And so again, I mentioned on the one with the commercial of 23, if I was dealing with just a subset, just single family residences, and I had lots of sales, I would not be very satisfied with that 23. But when I've got a data set that includes all different subclasses of commercial properties, including land, then that 23 is actually pretty decent. So there is still an aspect of knowing what you're looking at in looking at the COD, but it does give you a number that you can compare across data sets.
And that's great. And I thank you for explaining that a little bit more. I think I understand that a little bit more. I appreciate that. David, or Mr. Chair, do you care if I ask one more question? Just a quick follow-up.
Indulge yourself, Mr. Solomon Gross.
Thank you very much. So the cap rate in Juno is 6 or 6% or 7 of the motel, or motel hotels, how you put it. And the sampling you gave us was Seattle, a little bit of Anchorage, some Pierce County, more Seattle. I think you did an Idaho one. And Juno seems to be on the very top of this cap rate. Again, I'm not here to question you at all, but I just want to make sure that this is something that into these hearings that we're going to have, and I suspect we're going to have several, that as the assessors come up, that you guys will be able to defend this and say, why are we so much higher or on the higher ratio than everywhere else?
Well, and 2 clarifications on that. And that's why I mentioned earlier that the cap rate has an inverse relationship to value. If I lowered my cap rate from 6 down to say 4.5, that would result in higher indicated values. So by being at 6, I'm being more conservative than being down at 5 or 4.5. And I'm resulting in lower values. Part of the reason for doing that is that in doing, again, we have very limited data for Juno, but in doing the ones that I could do with a 6% cap rate and compare it to a sale, the values that I was ending up with were underneath the market by about the same percentage that our sales comparison is indicating, that 85%. And so that tells me that a 6% cap rate is giving us a value somewhat similar to the sales comparison level of assessment. So if I lowered it below 6, the values would go up.
Thank you. Thank you, Mr. Chair.
Yes,
Thank you, Michael.
sir. Ms. Meekum, your question.
An excellent presentation, and thank you for sending it out yesterday. I did have a chance to look, and it was great to hear it twice now. Very helpful this evening. Thank you. My question is about sales information, and that's a new process for the CBJ to receive. How is it being received, and then how is that being used?
So if I understood correctly, you're asking about the new mandate of disclosed sales prices?
Yes.
I can speak from my perspective. We haven't seen much difference, but maybe Mary wants to jump in and give a little bit of, or do you want me to continue?
We haven't seen a large increase in the amount of data that we're getting previously, just as a percentage of sales to sales information that we're getting. One of the caveats to this new law is that there's really not any enforcement at this point. So we may not see more data. And the other is that the ordinance makes it so that the sale prices are private. So we won't be able to share the sales prices with public. We won't be able to share the sales prices with the Board of Equalization or even the finance director or the state assessor.
Okay.
Does that answer the question that you had?
Yeah, it helps me understand it because it appears that by making these changes both to residential, but more so with commercial properties, you're really trying to come into line with the market, the sales market. And so having that information is helpful. I just wondered how it was being supplied and then how it is used when you're incorporating it into this data and using it.
So we send out letters to each buyer and seller of a transaction that we're somewhat certain is an arm's length transaction, and they mail that letter back to us that tells us what the sale price was. And then we insert that into our sales ratio study, and that's where we come up with the ratios between the sale price and the assessed value.
Got it. Thank you so much.
Okay, thank you. I have one question. While everyone's been talking, I've been trying to educate myself on what cap rate means. And it seems like it's something that gets added on to the assessed tax rate to come up with something. And can you, in 20 words or less, define what cap is?
Yeah, cap is short for capitalization rate, and it basically is talking about a return on investment. If I put $1 million into a property, how much do I expect to get back from that investment? And so it's highly influenced by other investment avenues. That's not the right word, but people investing in commercial properties, they have options of putting their money other places, stocks, T-bills. So it represents risk. It represents the other financial instruments that are available for investment. What kind of returns are they getting? What does a common person investing in real estate today expect as a return on that investment?
So with your example of $1 million property, and say it's a hotel here in Juno, you add 7% onto the assessed value of $1 million. Is that how that works? Or am I thinking this too much? Is it really?
I'm gonna blank on the formulas, but the formula is basically the three components are your income, your rate, and the value. And depending on which order you put them in, you divide or you multiply. So how it's utilized in the income approach is you arrive at a net operating income. You divide that by the cap rate, and that gives you a value.
Okay. Well, I guess if we have an appellant that comes in and starts complaining about cap rates, I'm going to turn to you for an explanation.
Well, and if we have any that come towards the board or before the board, utilizing an income approach, we will have a worksheet that will show exactly the steps that were done to arrive at that.
That'd be great. Thank you very much. Are there any other questions for the assessor? Barbara Schonberg.
Yeah, I had one other question. So we had this outlier sale of the Subport property to Norwegian for 20 million. Did that skew all the commercial properties? Is that part of why we have this big jump, or were we able to account for that arguably outlier sale?
That's an amazing sale, actually. And a couple things. One, it is in the sales sample. It was a legitimate sale. It went out for bid. There were bidders, and there was a winning bid, and they went through with the purchase, and the property's been transferred. So it was a legitimate sale, and it went into our data set to be analyzed. I was expecting that it might pop out as an outlier. It actually is not an outlier. From the statistical analysis, the definitions from IAAO of what constitutes an outlier, it's 1.5 times outside the interquartile range. And that property isn't an outlier. That sale is not an outlier, amazingly enough. No, we looked at a lot of other sales, and even if you don't consider that sale, the assessed values of our commercial properties were definitely under market. And we looked very carefully at the downtown. I looked a number of different approaches and a number of different ways of isolating the downtown, because my concern was with COVID and the tourism industry, is the downtown being hit more than the rest of the properties. And actually, when I isolated downtown, their ratio was lower than the overall. So if I were to make any kind of adjustment, they would get more of an increase than the overall increase. I didn't do that. I applied the uniform increase across the board, but there was no evidence that the downtown area should receive special treatment. And there was no evidence of the subport sale being an outlier.
That is so interesting. Just if I might, so there's, for commercial properties, the cost, the sales comparison, the cost analysis, and the income approach. Would you ever, to try and address an appellant's concerns, apply all three or more than one method to a single property to determine their assessment for the year, or is that not done?
In the appraisal process, we consider all three approaches. And the reconciliation process, or reconciliation is what the process is called, of taking those three approaches and reconciling them and coming down to a final value. And there's no formula. They discourage formulas on that. You don't just take the average of it and say, that's what you have to do, is evaluate which one is most appropriate, which one gives me the truest indicator of value. And then from the other approaches, how might I want to adjust off of that indication? And it's an appraisal judgment, it's complex, but that's the reality of how appraisal works.
Mm-hmm. Well, thank you, and thanks for the board's patience with my questions.
All good questions, and thank you, Michael, for a really great presentation.
You're welcome.
And now with a canine uprising in the background, Counselor, you've got the floor.
Mr. Chair, it looks like Ms. Meekum has her hand raised as well.
Okay, that's 2 strikes against me.
Oh.
Ms. Meekum.
One last question, just because of the Barb's subport question. In speaking with community members, would I be accurate to say that the changes to the commercial assessments, that process occurred prior to that sale, not because of that sale? Just for clarification purposes.
And no, it was in the set of data that was analyzed. It had no more weight or no less weight than any other sale.
But it wasn't the cause of your changes to the assessment process?
No. Without that sale, we would have done the exact same thing.
Okay, thank you.
Any final questions for the assessor? Hearing none, Mr. Gottschalk, it looks like we're ready for you.
Thank you, Chair. So my presentation is going to be a bit lighter, a bit fluffier, and thanks to Mr. Casey, it's going to be relatively short. So just wanted to introduce myself. My name is Adam Gottschalk. I'm a new CBJ attorney, and I'm going to be advising this board. I started a few weeks ago, so I don't have as much historic experience with the board as some of you may. So a lot of this is relatively new, and I'm going to have to research caps myself. But for starters, I wanted to give you my contact information. Well, actually, I'll do that at the end, just because my last name is relatively hard to spell. Well, I guess you can see it. So it's adam.gottschalk@juno.org. So I encourage you to send me any emails if you have any questions. I'm going to talk about conflicts of interest a little later on. If you have any procedural questions or any questions about the law, I am happy to do any research, and I will be likely learning alongside you, since as you may know, Title 15, where we're pulling a lot of our rules from, is relatively short and does not spell out quite everything. So we are going to be, or I am frequently going to be looking at cases. So if any issues have risen up, that's where I'll be turning after Title 15. So just going through kind of the outline that was provided in the packet that I believe first went out a couple weeks ago. I think was resent out a day or two ago. It looks like the first thing to talk about was the quasi-judicial role and responsibilities of the board. And Mr. Casey talked about that, and it pretty much explained most of it. So I'm just going to go in and flesh out and just see if there's anything else that we may want to cover. So part of being a quasi-judicial body essentially is that we do have a duty to be fair and impartial. As Mr. Casey mentioned, we don't want to exhibit bias or have bias or any preconceived ideas that would inform our decisions. It's important that, of course, all of our community members have faith in our, in your determinations and in the process. And giving people that fair hearing and that opportunity to be heard often can, it can often resolve the conflict. They won't appeal it, but they may. But we do want to be fair and impartial. So if you dislike a certain business, maybe a cannabis business, or if you dislike a certain neighborhood or a house style or an appellant, you don't want to let that influence you. You want to be making your decisions really on the evidence before you. And then Mr. Casey was saying, we are working with somewhat of a closed universe. So we're just looking at the evidence before you. So you're looking at the packet that the assessor has prepared. And I believe it was mentioned earlier that often the appellant or the taxpayer will come with their own information really the day of the hearing. So there actually doesn't appear to be any rule against that. As difficult as that may be, it looks like past practice has been that just take time to review that material. And if it does look like it may take more time or a future rescheduling, I believe that may just be the necessary next step, is that we postpone that particular hearing for possibly a later date if there's just too much to actually review for that day. Part of also being a quasi-judicial body is, and being fair and impartial, is that we don't want to have any ex parte contact either with any of the assessors about any of these subject matters or with any of the potential appellants or taxpayers about any of these subjects. I don't know if any of you have reviewed the board site, but they intentionally keep your contact information from being publicly listed right there, whereas it is on many of the other boards, because they don't want that ex parte communication possibly conflicting anyone out. Another part of this is members may not deliberate or vote on any matter in which they have a personal or financial interest. So personal and financial interests are explained a little bit in the definition sections of our code. So if you go to Title 1, it'll explain financial interest. So this can commonly come up if perhaps the appellant is someone that you sold a house to. That would be a conflict of interest. If it's something less clear, then you would want to email me, and I'm happy to look into it. If it's definitely something that is a clear financial conflict of interest, you would want to let your chair know so that your chair can anticipate that and have an alternate available who is not conflicted. And I believe it was mentioned that past practice, there is an alternate available on these hearings, but it is something to let your chair know. Another part of being impartial and fair is to avoid expressing opinions or including any commentary in the questions that you're raising to the parties. You're going to want to save that for the deliberation part or process. So you are, of course, allowed to dig deeper and ask for more details and ask a party to explain themselves more fully and keep probing. But you really will want to save opinions for the deliberation process. You can feel free to roll your eyes because that's not captured on the record. Just kidding, don't do that either. But yes, that was all for deliberation process. Due process, I think Mr. Casey went over that pretty well. Just as a reminder, due process does not require that you give parties an unlimited amount of time. So you are allowed to really set the structures and the parameters. And I believe past practice is that each party is afforded 15 minutes. Appellant will go first, and they will usually reserve several minutes for their rebuttal. So they'll do their 10, 13 minutes. Then the assessor is going to go, and then the appellant will have that 2 or 3 minute rebuttal period. I don't know if that's always strictly enforced, as we saw, and as we will all see very shortly. There is a lot of information to intake for a 10 to 15 minute period. So I think that really is going to be for the presiding officer of the panel to determine if we go over a little bit, or I'm not sure if anyone is really going to be super strict, but I believe that's probably up for the panel. And it is also up to the presiding chair to cut people off if necessary, or let them know at the end to start wrapping it up. Additionally, the presiding officer has that duty of kind of maintaining decorum. So if you do get an appellant or taxpayer who gets particularly heated or starts going off topic, then you're going to want to, the presiding officer is going to want to rein them in and possibly cut them off. Decide evidence. Again, as Mr. Casey discussed, you do want to make a record. So we do not have the strict evidence standards that you would in court, but you do want to use evidence that I believe the term is a reasonable person would rely on. So not just word of mouth that whatever house cost $100,000, it was built by that person. Like, you'd want to take in the factors that a reasonable person would consider. And you do want to make that record when you're talking about what factors you considered in determining whether to grant or deny the appeal. Legal standard, as Mr. Casey talked about, it is the burden of the appellant, taxpayer. All things being equal, we would defer to the assessor. So they do have to convince you that that there was either an unequal, excessive, improper, or undervaluation based on facts. And those facts, of course, need to be based on evidence. And one of the things that comes up pretty frequently are the late filed appeals. So an appellant does have to file a petition within 30 days of the mailing of the assessor's valuation or assessment. If they don't, they can file, I believe there's a form in the packet that they will file, kind of explaining why they weren't able to make that 30-day deadline. And those are rarely granted. It's a pretty substantial burden for them to show that they were unable to meet the 30 days. So it's not merely that they didn't check their mail or they were out of town. The burden is really on them to plan ahead. It's property owners are expected to be, if they're absent for an extended period of time, to figure out a way to be getting that kind of mail. So it would be really limited to situations in which the taxpayer was in a coma, or there's some medical incapacitation or anything like that, or rare circumstances in which they can't meet that 30-day filing deadline. So even if there are merits to their case, if it's late and it's not one of those rare circumstances and the board decides to grant them an appeal, unfortunately, that assessment is going to stay. I mean, that's really pretty much what I have for you. I don't know if anyone has any questions now. Happy to take those, or if I just share my contact information, if you want to give me a call or send me an email anytime, I am happy to look into any issues.
Thank you, Counselor. Anyone have any questions? Don't see any questions. So thank you for your time. Appreciate it. And I believe
Mr. Chair, I think we have Mr. Williams has just.
Mr. Williams has a hand up. Okay, go ahead.
Thank you, Mr. Chair. Just a question for Adam. Do the assessors or the, I want to say Clayton's, lack of better terminology at this late hour, have the right to have one of the board of persons hearing their case removed if they feel if there's a conflict of interest?
It depends. Well, I think we would have to hear what that conflict of interest is. If they just, for whatever reason, I don't see any, in just looking at Title 15, I don't see any reason why they would have like this kind of right for a peremptory challenge of just removing somebody and putting someone else in. I think that would possibly be up to the presiding chair if there's no reason not to switch the person with the standby alternate. But I don't see any reason why they would be entitled to that.
Okay, thank you.
Thanks for the question and the answer. Any other questions for the attorney? I don't see any. So Beth, on to our next topic, I guess, which is date availability for the calendaring of hearings.
Thank you, Mr. Chair. And I am going to defer to Ms. Cathcart on this because she's printed out the calendar with the potential date availability. There is the caveat that the assessor's office has to have 10 days in order to send the notice to the appellants prior to the hearing. So the earliest that we would be able to hold any Board of Equalization hearing at this point would be 10 days out from tomorrow, which if I don't know where the assessor's office staff is on their appellant processing timing, but so earliest would be 10 days out, and then we would be looking at, from my understanding, multiple hearings between now and until they're all heard. There's a very substantial number of appeals, it's my understanding. And so this may be going on for a couple months. The other caveat that I would say is that our clerk staff is going into election mode very soon. So we're going to have to do some juggling both with resources, electronic Zoom resources. I believe we're going to try and do these via Zoom to the extent that we possibly can. During the month of September through October, the assembly chambers will be in use for election purposes. So if we continue to hold these via Zoom, it seems the best method to do that. But we also have limited human and technical resources for conducting these. So with that said, I would turn it over to Ms. Cathcart to give the dates that she's come up with that those resources are presently available.
Thank you, Ms. McEwen. And I will send all of these dates out to the board as well so that you can look, because the other piece will be, we'll need to have at least even a general list of the appeals that may be coming before you, especially if there is a number of them, so that we can plan our, our set of 3 with an alternate. So I believe the assessors will get that to us, hopefully within the next couple days. And then knowing that, obviously some people will move off of it or have them resolved. But to just start to get a general idea. So what we have currently would be the week of the 26th. So, which realistically, I would say the 28th and the 29th of July. And then for August, is that right? Yeah, for August would be the 3rd and the 5th, so a Tuesday and a Thursday. August 12th. And then actually the week of August 16th, pretty much Monday, Tuesday, Wednesday, and Thursday. So the 16th through the 19th, we could hold multiple, pretty much any meetings that evening. So that is been my understanding, is that it would be, most likely multiple BOE hearings during the week. And then we move into the 25th and the 26th, which is a Wednesday and Thursday. And then we're down to the 31st of August and into September 2nd. Those are currently all dates that on our end of for the CBJ and no conflicts with Zoom, et cetera, and other assembly meetings. So those would be the dates to look at. And then, like I said, I will send those out. And once we can get the list from the assessor's office, then we can see. My understanding is they have some that are possibly ready to go. And then we can send that out, and that you can work with the attorney's office to see if it truly is a conflict or not.
Thank you, Ms. Cathcart. Ms. McEwen, any other items under this topic?
I don't know that we really need to go into it in depth, but if we are going to continue using Zoom platform for our appeals and the appeal hearings, Mr. Gottschalk had mentioned that there may be the potential for appellants to have evidence that they're presenting at the hearing. And I don't know how we can actually make that really work in a Zoom world per se. So I'm going to work with law staff to make sure and assessor staff are between the 3 offices. We will make sure that the appellants know that we need to have the resources that they're presenting available in advance of the meeting, if at all possible. Otherwise, we may need to postpone that particular appeal to a later date, because in the Zoom world, sharing screen is one thing, but depending on what the evidence is, you do need the time to digest it in advance of the actual hearing. So that would just be one item of note that we're going to have to work through on the staffing level. Thank you, Mr. Chair. And
Thank you.
Have Mr. Williams and Mr. Solomon Gross's hands are both up.
Mr. Williams.
Thank you, Mr. Chair. The question I have is, I'm kind of old school, and I hate to say that because I always thought I was a young person, but I like papers. And how are we going to get paper copies of everything for these appeals so we can have them compared to just emails? Because I like to take notes when I read things, and I don't have that capability. I'm probably one of the last people without a printer in their home to have that. And doing this as a volunteer basis for the city, how are we going to rectify that issue, if that makes sense?
Thank you, Mr. Williams, if I may, Chair. You beat me to it. I was realizing that I had actually not made that notation to the board, is that we can do it both ways. We will be sending out paper copies to all of the appellants, and happy to also send paper copies or have them available for you to pick up at the city clerk's office, or we can try to drop them off at your house. I know, especially since lots of times there may be color photos, you know, they can be large documents. And we will also send it as a, most likely a Zen2, like a file share program for those that like to have both or would prefer to have it electronically. So definitely happy to work with each of you on personal preferences and needs, as well as following what is the general requirement. So I'm happy to work on the side with you for that, of either dropping it off, having you pick it up, or strictly electronic.
Thank you.
Thank you for the question, Mr. Williams. Mr. Solomon Gross.
I will unmute myself. Thank you, Mr. Chair. So I just want to make sure that we will not be doing any of these in person. Is that right, Madam Clerks?
Through the chair, Mr. Solomon Gross, that is our current practice for non-assembly meetings. We are gradually rolling out in-person meetings, but we are with assembly and assembly standing committee meetings only, and we are still working through all the COVID protocols and practices. And so as time goes on, we may eventually get to in-person hearings. But at this time, anything that's not an assembly or assembly standing committee, we are strictly doing via Zoom.
And just a quick follow-up, Mr. Chair.
By all means.
So I know you say that there's several. Is several meaning hundreds or 50, or and how many can we expect a night?
I would defer to Ms. Hammond for that answer.
We still have a large number of commercial property appeals that are outstanding. I wish that I could give you a better number, but it's probably going to be somewhere between 50 and 150 appeals. Lots of those will be single property owners with multiple appeals. We expect to have conversations with folks and explain the assessment process, and I believe that many of them will withdraw their appeals. There will be times when we find that there was some error in our assessment, and we'll make corrections to those. We will do our best to manage the number of appeals in a given night. For example, I've got a property owner with 26 properties, and we may just have him on his own for one night. If we've got a more complex appeal, then we'll probably have one or two. And if we have appeals where we didn't get any data from anybody or from them, then we'll probably lump some of those together.
And just one more thing, Mr. Gottschalk, I just want to make sure that I got your information correct. It's adam.gottschalk@juno.org.
Yes, that's correct.
And then do you want to provide us with a phone number or not?
Yeah, absolutely. So if everyone is ready to take it down, it is 907-586-5242, and then it's extension 4108. So if you're just calling the Department of Law here, it's the standard 586-5242, extension 4108.
And welcome to the city. Congratulations.
Thank you. No, I'm looking at this. I think this is going to be fun. Wow.
And Mr. Chair, if I might piggyback on Mr. Gottschalk's comment about the phone numbers, citywide, we have had an overhaul of all of our city phone numbers. And so for those of you who may have already had our phone numbers on file for clerks or anyone else, those have changed and we're happy to provide those to you as well. But the main number for the city clerk's office is 586-5278, and it gives you a voicemail tree and you can dial one of our extensions from that voicemail tree. And I do see that Mr. Mackey has his hand raised as well. Thank you, Mr. Chair.
Mr. Mackey.
I absolutely forgot what I raised my hand for, but I remember I had a good question. So if it comes back to me, I'll re-raise it.
It is 8:30. Time for bed.
Hey, it is time for bed. But first, just indulge Ms. Hammond and ask her if she has any short comments for the board.
I recognize that all of you are volunteers and I appreciate all of the time that you're going to spend with us. We do our best to resolve appeals before they get to this period. This has become kind of a political year as far as assessments. And so I think that's why you're going to see more appeals than the folks that have been with us for a while are used to. So I appreciate your patience and your service.
Mr. Chair, just one more thing. During this very long meeting, I would like to show everybody that I did become a grandpa.
Mazel tov. Mazel tov.
So Rowan was born about 45 minutes ago. So I was still paying
cow.
attention to everybody, but I have a bunch of pictures and I'm super excited. So
That's first one.
it's actually our third. So it's our second COVID baby. So my other son just had one a couple months ago. So.
Okay, thank you for sharing. Mr. Mackey, did you resolve your senior moment?
I've only been 50 for like 8 months. So let me see here. Actually, I noticed I stopped getting emails on my work email and started getting them on my personal email, which I cannot access anywhere except for my home. Is it possible to get those switched over? And if so, how would you like for me to notify you? Just email you from my work email, Beth?
Thank you, Mr. Mackey. And yes, I think we still have it on file, but if you wouldn't mind just shooting it to the city.clerk email, then we have it and I'll switch it out to use that one instead of your personal one.
You can use them both if you want, honestly, and I'll put that in the email. It's just I had a real gap of, oh boy, we're being really quiet. So I was a little bit blindsided coming to this meeting, finding out how busy we really were going to be. So, but anyway, I'll email you and give you the give you the reminder. Thank you.
Perfect. Thank you.
Thank you, Mr. Mackey. I do have one closing comment, but first, any last minute comments from the board or anyone? I would like to, before we adjourn, say thank you sincerely to all the board members for volunteering and especially to our new members who I believe, subject to correction, are Ms. Meekum, Mr. Sonnenberg, Ms. Lane, and Mr. Williams. Do I have that correct? Are there any others?
Miss Lane is actually with the law department. And so Mr. Sonnenberg, Mr. Williams, Ms. Haynes, and Ms. Meekum. And then we also have one additional member that was unable to attend tonight. It's like I'm having my own senior moment, sorry.
It's Mr. Coleman and actually Ms. Haynes has been on for a while. So
that's right. It is a senior moment. Sorry, everyone. And I want to echo Mr. Epstein's thanks to everybody who is serving, those who are veterans and those who are new to this. It really is a wonderful thing to see this many people that are willing to serve our community in this way. And it's not an easy job. I personally was getting lost in the weeds of some of the presentation earlier, and I've been sitting through these BOE meetings for quite some time. So I appreciate everybody's attention and hard work on this. And we're here to help facilitate it for you. So if you have any needs of the clerk's office, please don't hesitate to reach out and give us a call or send us an email.
Thank you.
Thank you, Madam Clerk. With that, I would entertain a move to adjourn, a motion to adjourn.
Move
So
to adjourn.
moved.
Mr. Mackey has moved to adjourn. Mr. Williams, second. Are there any objections to this motion? Hearing none, that's good because it's bedtime. Good night, everyone, and thank you for attending.
Thank you.
See you guys later.
Thank you, David.